with the reading of the notice and a roll call. And at this time, will you please join me in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic which stands, one nation, under God, indivisible, with liberty and justice for all.
At this point, I will open the meeting for comments from the public on items not on the agenda.
Good evening, Mr. Miller, members of Princeton Council. I'm Daniel Harris, 28 Dodds Lane. With liberty and justice for all, we cannot pass through this evening without remembering the murder of Mike Brown. This is a municipal matter for every area in the country. It is a matter for all of us personally. It is to be hoped that there will be some expression by all of us in the community of outrage, dismay, and a renewal of purpose and dedication sometime within the next week or so. Details to be announced. Everything is still in flux. We're all, I think, stunned by the magnitude of this tragedy that continues to happen across our nation, whether it is in New York, whether it is in Los Angeles, Florida, or most recently, Missouri. The age of lynchings should have passed. It has not passed. The age of legalized murder should have passed. It has not passed. And there are many of us here who simply need to make good on the claims of the Constitution, which is founded on a falsity, as we all know. The Civil War was designed to reclaim that falsity, and when we moved back into Reconstruction and Jim Crow, we gave up the ghost again. We cannot afford again to do so. Thank you very much.
Are there any further comments from the public on items not on the agenda? Seeing none, I will close the public comment part of the meeting and move ahead with a discussion of Resolution 14228, authorizing execution of the amendment to the Avalon Bay Developers Agreement. Before we engage, would you? I think you can hear me clearly, Dr. Hamid. The meeting was opened for comments on items not, N-O-T, not on the agenda. If you have a comment on items not on the agenda, please step forward and make your comment. Yes. We'll now proceed with a discussion of Resolution 14228, authorizing execution of the amendment to the Avalon Bay Developers Agreement. And I'd like to lay out some ground rules before we proceed with the discussion. First of all, I know there are a number of you here tonight that want to speak, and I welcome your participation, but I would like to point out that we would welcome your comments, but we would prefer not to engage in debate as you proceed with your comments. Many of you may have questions. We'll endeavor to answer them after we have collected the questions and have an opportunity to put them together. Please try and limit your comments to about 3 minutes. I'm not going to use a timer. I think we can all roughly approximate the time of 3 minutes. And if you agree with the comments of a previous speaker, please say so and save us all time in the process. I'm going to start the discussion by asking our legal counsels to do two things. One is to take us through how we got to where we are today on the developer's agreement, and to give us a legal interpretation of what transpired in court to bring us to this point. And then, secondly, I'll ask our legal counsel to present the proposed developer's agreement in the context of how we got to the point that where we are in terms of the technical aspects of the agreement. I'll then provide an opportunity for counsel here to discuss, comment, question what they've heard, then open the meeting for public comment on what you will have heard, and then finally bring it back to council once again. So with those ground rules, I'll ask Ms. Cecil to begin the process and take us through the chronology and the legal interpretation.
Well, I think this begins really back in January, which was the first time that the council had the developers agreement on its agenda for consideration and approval. This is an agreement that the planning board required Avalon Bay to enter into with the town as a condition of the approvals Avalon Bay received from the planning board last August. At the outset of that meeting, Avalon Bay's representatives stood up and basically presented to the council or told the council that there had been historically the use of an incinerator at the hospital site, that they had not, I think, been aware of it previously, but that now they were. And they proposed a very specific testing protocol in connection with that incinerator. I believe it involved televising the floor drain and lines leading out of the incinerator room. The council and the town's professionals didn't feel that they had the expertise to decide whether Avalon Bay's proposal was adequate. So at the conclusion, or at the end of the January meeting, the council retained Ira Whitman, who is a licensed site remediation professional and actually sits on the licensing board. The council retained Dr. Whitman to review the information about the incinerator, review what Avalon Bay was proposing, and advise the council on whether that was going to be sufficient. Dr. Whitman came back with a report that he presented to the council at its March 10th meeting, and that report was the result of his review of documents and materials regarding the incinerator, his own inspection of the site, and conversations that he had with Avalon Bay's environmental expert. And it contained a series of recommendations for testing, additional air monitors, and certain other miscellaneous items, all of which Avalon Bay had agreed to, and this was set forth in a letter from Avalon Bay to the council. During the March 10th meeting, a question was raised about an earlier draft of Dr. Whitman's report and whether the March report that he had issued represented his own recommendations. And he indicated that no, what was in that report was the result of some give and take with Avalon Bay. He termed it a negotiation. I think more accurately, it was an exchange of information and a discussion among environmental professionals. But the upshot being that it was different from some of his earlier thoughts, and the council charged him with coming back and giving the council his unvarnished recommendations, not something that was the product of a discussion, or as he termed it, a negotiation with Avalon Bay. That is what he did in April. He issued an addendum, I believe it was dated April 3rd, and it was presented to the council at its first April meeting. And the addendum to his report basically went beyond the recommendations that were contained in his March report. He had a number of additional testing recommendations that he was suggesting the town require. Avalon Bay made it very clear both in a letter to the council before the meeting and then at the meeting itself, that if a town required anything beyond what Avalon Bay had agreed to in March, Avalon Bay was not going to do anything. No testing whatsoever on the site. The council, though, faced with Dr. Whitman's recommendations, and I think you were all very clear about this on the record, you had received advice from your own professional, you felt compelled to follow that advice, and it was his April set of recommendations that were incorporated into the developers agreement that the council approved that night and sent to Avalon Bay for signature. As Avalon Bay had indicated it would do, rather than sign the developers agreement, it filed a lawsuit against the town, challenging the town's authority to impose any environmental testing conditions whatsoever beyond what the planning board had imposed through its approvals. And that's the litigation that we've been fighting for the last few months. In the context of that litigation, Avalon Bay filed an application with the court for what's termed a preliminary injunction, or interim restraints. What it was really asking the court to do was issue an order that did a number of things, but that all ultimately led to staff issuing Avalon Bay the demolition permits that it needed to start taking down the hospital buildings and proceeding with that with none of the environmental testing protocols that the town was requiring. Neil Yaskin and I went to court in July to argue over that application. We were successful in getting the judge not to order the immediate issuance of the demolition permits, and there was a big but attached with it. The only reason the judge denied their application and didn't issue the order was that she felt that they would not suffer irreparable harm if they had to wait until she made her ultimate decision on the merits of all of their claims. What she then went on and did in, I think I could correctly characterize as exhaustive detail, was discuss then the merits of their claims. And she indicated in no uncertain terms that she found their arguments compelling and that there was a very strong likelihood that at the end of the day she was going to rule in their favor. And she deliberately set forth her reasons for that on the record, and one of the things that I was really struck by as she was doing this was the amount of independent research she had done. In other words, this wasn't a case of which lawyer had presented the more persuasive arguments. This was based on her own independent research. She was citing cases that neither side had presented to her, and she had really looked into the issues in depth. And her concern was that she could not find any authority that supported what the town had done. I think she was very sympathetic to the situation that the council was in. I had no sense from her that she felt that what you had done was wrong in the non-legal sense. She was very clear, however, that she couldn't find legal authority to support the requirements that the council had imposed. And at the conclusion of putting all of this in the record, she ordered both sides to attend a mediation session with a professional mediator who works for the state and who thankfully does this free of charge when municipalities are involved. So that's how we came to enter into mediation with Avalon Bay. Now, mediation is a settlement negotiation with a professional who can guide the discussions and try to help both sides reach a mutual agreement. You're never obligated to settle through mediation. I want to be clear about that, and the judge did not order the two sides to reach a settlement. However, I think what she was trying to do was give both sides the opportunity to get something and to try to find a solution that was going to be satisfactory to everybody, and again made very clear that if we pursued this to its conclusion, we would probably be very unhappy with the outcome. So the mediation took place the first couple of weeks of August. I was there for the first mediation session. Then I was out of the country, so Mr. Yaskin was there for the second mediation session. And the mediation did result in terms that the mediation teams agreed to, and that's what led to the amended developers agreement that is before you for consideration tonight as a full council. And Mr. Yoskin is going to go into more detail as to what that amended developers agreement calls for in terms of the remediation that would now be required of Avalon Bay, and that Avalon Bay is agreeing to do if the developers agreement, the amended developers agreement is approved.
The amended developers agreement before you was negotiated in the context of a difficult legal environment for the council. DEP's regulations governing the remediation of sites actually allow, indicate that there are minimum standards, and they allow municipalities to enact more stringent standards, provided that it does so, the municipality does so, pursuant to a duly enacted ordinance. Our arguments notwithstanding, Judge Jacobson said that she could not find any ordinance that would support the town's action in this circumstance. So we were confronted with a situation where if we pressed the issue to its merits, we might walk away without any testing of this site, the kind of testing that the town wanted whatsoever. This is an odd situation. Sites are subject to testing requirements in New Jersey if there's a documented spill. The Spill Act says if there's evidence of a discharge, it has to be investigated. If a site is an industrial property that's being sold or closed pursuant to the Industrial Site Recovery Act, there's certain investigations that have to be done. That statute does not apply to hospitals. So as incongruous as it may seem, there is no mandatory testing requirement for this site. What Avalon Bay did when it presented its application to the planning board, when it purchased this site, the agreement between Avalon Bay and Princeton Hospital said that the hospital was making no representations and warranties with respect to the environmental conditions on the property, and it left it to Avalon Bay to do whatever due diligence it felt appropriate. Avalon Bay engaged in a due diligence process pursuant to the American Society for the Testing of Materials Standards. It went through, it identified what there were certain areas of environmental concern, the most obvious of which are underground storage tanks, and that was the investigations that Avalon Bay conducted. As Trishka noted, the evidence of or solid evidence of the incinerator was developed after the matter was decided on by the planning board. Avalon Bay's due diligence did not disclose the presence of the incinerator. Once they understood that there had been an incinerator there, Avalon Bay did propose certain testing in March. There was going to be sampling, I believe, in 2 different soil locations to see if there were any constituents associated with emissions from incinerators. And incinerators can have really 3 pathways, contaminant pathways, the most obvious of which is emissions through a stack. The second is contaminants making their way through the floor of an incinerator room into the groundwater, or if ash is either exported from the site or buried on the site. So Avalon Bay proposed limited testing, 2 locations on the site that Dr. Whitman initially agreed to. Dr. Whitman later said that he thought that more expansive testing was required and for a wider suite of contaminants, including the possibility, the minimal possibility, that there were PCBs that had become embedded in the concrete around the property. Avalon Bay was unwilling to do that. The litigation ensued. So here is what we have. Since the purpose of testing was to identify if there was any risk to the public, the more sensible thing to do, it seemed to us, is to eliminate any possible contaminant pathway. So what we asked Avalon Bay to do and what they agreed to do was scrape off the top 4 inches of all of the topsoil that's currently exposed on the hospital site. To take that material, segregate it, and when it is reused on the property, reuse it at locations below grade where it will be either under pavement or it will be adjacent to deep foundations where there's no human contaminant pathway. In selected areas on the property, the excavation will actually be to 12 inches, and those are where the public park is proposed, where the community garden is proposed, and in the 2 locations where there was going to be testing. The logic was that if that was the highest potential for any material to be there, then why not simply excavate it and encapsulate it? And then finally, although the floor of the incinerator room appears to be intact, Avalon Bay has agreed when the floor is pulled up that the first 12 inches of soil below the contaminant, below the incinerator room, will likewise be used subgrade. In addition to that, the replacement on top of the 4 inches that were removed, that'll be certified clean fill coming from off-site, and then in the 12-inch excavation areas, there will be 12 inches of clean fill from certified off-site locations. There will be, during all excavation activities around the property, there will be 5 air monitors to test for airborne particulates that get activated by wind or by machinery. These monitors don't do qualitative testing, they don't do chemical sampling, they test for the presence of particulates. These monitors will be set at 1/2 the DEP minimum detection limit, which is, I believe, 75 micrograms per cubic meter. So it's a very, very low threshold. They have noise alarms, and also the health officers on site will have remote devices that tell them if they go off, and if that happens, then all activities on the property will cease until either the areas are watered down or the wind drops below a certain speed. 2 more elements to what Avalon will do. There is a floor drain in the incinerator room. When that floor drain is removed, a sample will be taken of the material immediately below the floor drain and will be tested for a variety of pollutants. It's called priority pollutants, which is 13 different metals, and they're also in the priority pollutants are what are called TICs, or tentatively identified compounds, which are indicative of the presence of other compounds. So it's a wide range of testing. And then after the drain is removed, a TV, remote TV, will be put through the drain and will run out to where it meets the sewer lateral. If there are any breaks in the line, where those breaks are, they will be subject to the same sampling as was done where the drain is. And then finally, all soils will be scrutinized during demolition and excavation of the property. There will be at least 2 and likely 3 health professionals on the site. Princeton's own health professional is a certified health professional. I believe Avalon Bay plans to have its licensed site remediation professional on site, and if the town so chooses, somebody from Dr. Whitman's firm can be on site. At least one of these individuals will have a photoionization detector. It's a wand-like device that detects volatile organics, petroleum hydrocarbons, things like that. It does not detect heavy metals. I mean, we will acknowledge that there is no visual or olfactory evidence of heavy metals, but heavy metals, any metals that are associated with the incinerator, should not be. In fact, it's almost impossible that they would be at the depths at which that work is being done. And then the environmental professionals will be on the lookout for any ash residue. Ash residue is readily visible. If it's found, it will be collected, it will be tested, and it will be disposed of off-site. What did the town trade off for all of this? The testing that was going to be done at the 2 soil locations is not going to be done. Instead, the material is simply going to be collected and placed in subsurface locations. And finally, PCB testing will not be conducted. Dr. Whitman did indicate at one point that he thought that it might be warranted, but that it was always a low likelihood of the presence of PCBs, and it was based on the hypothetical presence of materials in the hospital that would have been thrown in the incinerator, which he indicated was an unlikely scenario. There's also been a weathering effect. The incinerators, there were 2 over time, have not been used for many, many years, and if there were PCB deposition in any concrete areas, there's a good chance that it was weathered. We worked with Dr. Whitman at every point during the mediation process. He did not attend the mediation, neither did Avalon Bay's environmental consultant, but I was in touch with him constantly during the mediation. So that's what we've gotten. That's what we gave up, and on balance, given the goal of trying to isolate any material that might be on the site and to eliminate any contaminant pathway, we believe, with the advice of Dr. Whitman, that this is the best result we can achieve in light of the very real legal potential that we could not get any of this if we pursued this matter to a conclusion on the merits.
Thank you, Mr. Yaskin. At this point, I'd like to turn to counsel and let them ask any questions or make any comments they'd like to make.
Ms. Cecil, can you tell us what would be the problem with delaying this agreement? We've been asked to delay it until more people are likely to be here.
I think if you delay this, basically you'll have no agreement. Avalon Bay will walk away. And you're also under a lot of pressure from the court to get this done. And a third factor that's placing a lot of pressure and time constraints is that Avalon Bay has filed a motion for summary judgment with the court that it's asked Judge Jacobson to decide on September 6th, which is coming right up. And that summary judgment motion, again, goes to the ultimate merits in the case. Right now is when Avalon Bay's motivation to settle is at its highest. The contractor on the site is pretty much nearing the end of the work that it can do without demolition permits. And Avalon Bay has every incentive to keep the work going, so it needs demolition permits as soon as possible. That's what's driving Avalon Bay to come to the table and agree to what it is agreeing to. I think every week that the council delays making a decision, the work stops on the site, Avalon Bay starts to lose a lot of money, and the incentive to settle goes away, the incentive to litigate ratchets up. So I think if you want this agreement, you have to act on it now.
Thanks.
I was just going to mention about the drain. Some people have expressed concern in the past that the televising the drain would not be sufficient, and I think, I don't know whether I heard you say that our staff will be on site, that they've said that they've agreed that our staff will be there. They're going to notify us when they intend to dig up the drain, and so we'll have people there to visually inspect the drain as it's being torn up, and so that if there were things that somehow the televising this didn't pick up, we'll have people on site.
That's correct.
Yeah, I just want to say thank you. Can you just, Trishka, just repeat, if we didn't, and I think the question was asked, and you laid out some options, but if we didn't accept this agreement tonight, and if we had to go back to court, then we would be left with nothing, basically in regard to testing? Is that what?
Yeah, I think that's the likely outcome. The judge was careful to indicate that she hasn't made her final decision, and obviously there are more arguments to be made, both on paper and orally, and, she hasn't given her final word. However, she has given us what was clearly almost her final word, and as I said, was based on extensive research that she had done. So it's not like she wasn't familiar with the issues. And I think she did that deliberately to try to give us the opportunity to get something. So my concern is if you press the litigation, I think there is a very, very strong possibility, if not outright likelihood, that you're going to end up with nothing.
If I can simply continue that vein of question, if the judge rules against us, what are our options? And what would you consider the likely outcomes to be?
Your only option would be to appeal that decision. And I think one of the things that you need to be aware of is that if Avalon Bay wins, the salient outcome is the town is ordered to issue demolition permits and Avalon Bay proceeds with the demolition. In the interim, the town can appeal that decision, but the fact of filing the appeal will not stay the court's decision, meaning Avalon Bay can proceed with the demolition. You would have to make a separate application to the appellate division for an immediate stay of the trial court's decision, and again, it's the same standard that we were arguing over with Avalon Bay in July. But so you'd have to demonstrate, for instance, to the court a likelihood of success on the merits of your appeal. But you'd be doing this in the context of the trial court already having ruled against you, and a fairly deferential standard of review that the appellate division would be applying to what the trial courts had decided. So I would caution you against thinking that you would be able to get that stay. I think the possibility of actually getting a stay of the trial court's decision would be really remote. So what would happen is, my estimation, Avalon Bay would proceed with the demolition while the appeal was pending. And so even if at the end of the day you were successful, my concern is it would be a success, you'd be successful on paper, but the buildings would be down and you would not have had the type of testing and remediation that you're seeking here.
Just to go back to Dr. Whitman, am I hearing correctly that replacing the soil, the layer of soil that will come into contact with anyone, 4 inches in some places, 12 inches in another, that he felt it was essentially essentially the same protections as the testing that we had previously asked for?
Well, as I understand it, and I can't speak entirely for him, but as I understand it based on our discussions, he considers it to have given a higher degree of protection. Metals, if they're there, and substances like dioxins and furans, which are associated with thermal destruction processes, incinerators, they adhere to molecules in the soil, and they can be very random. You can test here and not find it, and it can be an inch away. So you could test and not find anything, and there could be things there. Conversely, you could test, find things, and there's not much else there. The more prudent thing to do is simply assume that they might be there and remove them. So on the whole, he felt it's a better result, and I feel it's a better result. It raises an obvious question. People are going to say, but wait, you're taking material which may be contaminated, and you're enclosing it below the surface. That possibility exists, but we're talking about very, very low levels, if it's there at all, and there are certain contaminants that are ubiquitous throughout the built environment. Lead is a good example. So every time a site in Princeton gets rebuilt and there's development, or every time a sidewalk gets dug up and the town spec is 4 inches of clean soil, chances are at least lead is being disturbed, and probably other things. So if you take that soil and put it somewhere where it can't come into contact with humans, you're better off.
Could I would just add to that, the other outcome is that we tested and we find some things at some level that don't require Avalon Bay to take any action, but with which we as a community are not happy with. So, some of these testing levels would have come back. Again, we think that just removing them all together and putting them beneath the surface is a better solution than coming up with something that, just by some small fraction didn't meet a threshold that caused them to take any action. I think it's also worth mentioning that they were fully willing to assume whatever risk there is in the soil. They had every intention of reusing it. So they're comfortable with it, but nonetheless, they were willing to accommodate us.
Any comments from our staff? Mr. Kaiser, Mr. West?
Staff had an opportunity to discuss the proposed settlement agreement this afternoon, and Mr. West and I spoke with Mr. Grosser, our health officer. And Mr. Grosser was particularly pleased with the arrangement that the 4 inches of topsoil would be removed, and he felt with that occurring, there would no longer be a concern with human contact with any contamination in that top layer of soil. So because of that and because of the monitoring that will be occurring during demolition, staff feels comfortable with the settlement. And Mr. West may want to comment further.
Nothing more.
Thank you. Any further questions or comments from members of council or from staff? I'd like to just make one comment about the suggestion that perhaps this could be deferred to the next meeting, and that is the next meeting of council is scheduled for the 25th of August, and believe it or not, we do have a rather full agenda for that meeting. And if we were to go beyond that, we're into Labor Day and into the first part of September and up against the hard deadline that was laid down by the judge. So I do not see deferring action as an outcome that would yield anything worthwhile at this point. If there are no further questions or comments from council, I will open the meeting to questions and comments from the public. I'll ask you to state your name, place of residence, and please, as I asked before, try and stay within roughly the 3 minutes. And if you'd like to line up at the podium, please do so.
When you give us the word, we'll wait for you to give us the word.
Please proceed.
My name is Dr. Sam Hamad, Hamod, 282, 284, 286 Witherspoon Street, Princeton, New Jersey. Thank you very much, members of the council. I applaud you for your diligence, and we want to thank you very much. It's a difficult job because no one is ever satisfied in this world. And we know that you're aware of this, but we want to thank you for what you have done, and we appreciate that. I do want to say, in a note of caution, though, that I think it would be advisable, even with time constraints, that I need an answer from Ms. Cecil. Ms. Cecil, what do you mean by voting now? Does that mean tonight, or within the next 4 or 5 days, or a week? I don't think the word now is very clear.
Would you comment on that?
Yes, I mean voting tonight.
Okay, I would raise a real question for you and the council. The mayor is not here, nor is Ms. Howard. I do think, since we have a democratic situation here, it would be very, very unfortunate if you were to vote tonight without those two members in attendance. I think you want to be fair to yourselves as well to us. And remember this, you represent the citizens of Princeton, not Avalon Bay. I know you want to be fair to them. We want you to be fair to us, and you should be fair to yourselves. Miss Cecil, the second thing is this. Did you bring any evidence outside of the constraints legally that there was no law on the matter, but did you bring the ethical argument and the environmental arguments to play in your presentations on behalf of the city of Princeton? Or did you stay within the limited legal aspect that there is no ordinance about this? I need to know this because my practice of law says it should have been brought up.
Dr. Hammond, I wrote that part of the brief that dealt with the environmental issues, and we made the argument that the environmental impact statement requirements that are listed in the township's land use ordinance allowed the planning board and by inference the governing body to attempt to do what it was doing, and Judge Jacobson indicated that she said, nice try, counselor, but that does not work for me. So all of the environmental issues that are at play here were brought before Judge Jacobson. She was well aware of them. She said she was not unsympathetic to them, but we are all constrained by the law.
I understand that, and I thank you very much, Counselor. My then advice would be that perhaps we should consider an appellate appeal with an injunction against them moving forward now and penalizing us, because at one point, Ms. Cecil, you said, if we don't agree, then they'll walk away. What does it mean, Ms. Cecil, that Avalon Bay would walk away? Would we lose, or would Rabner and the Princeton Hospital people lose? Who would actually lose?
But I think the implication was that Avalon Bay would walk away from any agreement at all, and we would be left with only the statutory requirements from the DEP as far as the site is concerned.
That's the sense I had. I wanted a clarification. Thank you for clarifying that. And then one last comment, and that is that I think we want to find a way to have peace with Avalon Bay, and I know it's going to come. We're aware of that. They have a good attorney, and they have a good motive to take over this site. We want them to do it. All we were asking is that perhaps we should think about, if we don't do it now, and if we do agree with this, then, Mr. Kaiser, we do need some ordinances. Right now, our ordinances, according to Mayor Jim Floyd, are lacking, because when he went down to check on ordinances, there weren't any, as Judge Jacobson said. The question is, though, how accurate is Judge Jacobson? Because every time we've come with things from the citizens of Princeton, whether it be the Dinky or this or that, she continually rules against us. And I'm a little disturbed by this, because I know there are good lawyers who could probably bust her. And I'm really not satisfied that she's that good a judge, and you're assuming that she's going to get away with some of these decisions. I think some of us are starting to raise questions about her ethical positions and who she's being, leaning toward. Because judges do this. I remember the first week of law school in University of Chicago, they said to us, 40% of the judges are corrupt, 40% are ignorant, and if you get the 20% who are good, you're lucky. My hope is we will try to find a better judge. So I'm not sure, Ms. Cecil, that we should just give in to the situation. Again, thank you very much, counsel. And again, I would pray, and I use this legal term, pray, that you will wait until you have the voices of our mayor, Ms. Lempert, and Ms. Howard to join you before you make a decision. And I would not be pushed by Ms. Cecil or by Avalon Bay. And if you are, I think it's to our detriment. Thank you very much.
Bruce Lee, 80 Spruce Street. I have no doubt the demolition is going to take place. But one of the things that I have some questions and concerns. because I believe the devil's in the details. And one of the things I'm concerned about is the chimneys. Dr. Whitman didn't do any testing inside the chimneys that evacuated the burning material from the incinerators. And I'm concerned that when those chimneys come down, there may be some heavy metals that are going to be let loose from what was inside the chimneys. So my question is there any way that we can be sure that that does not happen? And the other question is about the testing itself. Is the soil testing going to be done before the demolition begins, during the demolition, or after the demolition is completed? That's all I have to say. But I would like answers to that if possible.
No, we're going to answer. I didn't know whether someone would be responding. Okay. Victoria,
As I said at the outset, we're going to note the questions and try and answer them after we have them down on paper and can put together like questions so that we don't wind up answering questions over and over again. And I'm not inferring that anybody has, and I'm not inferring that anybody has repeated questions, but we'd like to group the like questions and address them at that time. And that'll be done tonight as best we can.
Victoria Ergo, Jefferson Road. I have a question, and perhaps this is best addressed by Attorney Yoskin based on what he said so far tonight. But first, I'd like to say, based on what I understand about what's been said on the legal issues, it looks to me as if this is a necessary settlement, and based on what I've heard and understood so far about the environmental issues, it also seems to me to be a rather beneficial settlement. So, but there's this one loose end that I would like Attorney Yoskin to address, perhaps, and that is how does the potential for contamination as a result of the historic liquid waste stream that went into the septic system prior to the connection to the public sewer, which I can't remember exactly what year that was, but it was pretty late in the game, in the 70s or 80s. How does that potential contamination figure into what's been proposed as a settlement in terms of removing 4 inches or 12 inches and capping? There's probably some capping going on. In terms of how that deals with that potential contamination, it probably does, but it's not been stated on the record yet. Thank you.
I think that's one we can address right now.
Yeah, I'll try and answer the question. I'm not familiar with all of the details of the alleged septic system. I understand that some people believe that for a period of time the hospital operated on a septic system, but if it did so, it was many decades ago. More importantly, nobody's discovered evidence of that septic system yet. So I'm looking to Mr. Kaiser for that. But it is correct that there were solvents and other compounds used in the hospital that went into the sewer system, and this agreement requires that as the sewer lines, there's one sewer line that's going to continue to be used, but if any underground pipes are unearthed during excavation, they will be inspected. If there are breaks in the line, there will be soil sampling conducted where there are breaks in the line.
Paul Driscoll, Harris Road, and I'm actually requesting that council this evening delay its vote on the amended developers agreement until residents have had ample time to fully review and consider its impact. The documents were posted, I think, on Friday. They do cross-reference the Whitman addendum, and they may look simple and self-explanatory on the surface, but we have all seen in the past how a misprint or a typo or something can change the whole meaning of a document, and this does involve the safety and welfare of our citizens. And I don't understand the rush. I did go to the court hearing. I do know what the judge's timetable is. You have time to submit briefs on August 29th with follow-ups to responses on September 15th. And a lot of people can't be here tonight. They're on vacation. I'm sure there were more people that would like to know more about it. This is the biggest demolition in Princeton's history. People need to be informed. People need to be involved. So I hope that we will have a chance to have a chance to review it, and maybe next week have an open question and answer period. It's extremely important. Also, I would like to say that Avalon Bay is to be our business partner for the future. Make no mistake about it. The size and scale of their operation makes them our partner. Now, when you go into business with someone, good business partners of integrity, it's all about making and keeping promises. Some of you are in business and you know this, or have had backgrounds in business and know this. From the beginning, Avalon Bay has had a long history of duplicity in communication with the town about demolition and its environmental impact. Is it any wonder that neighbors are extremely apprehensive? Let me give you a couple of examples. September 15, 2011, Ecosciences conducts Phase 1 study. Avalon Bay's own consultant recommended a subsurface investigation that should be performed to determine if the underlying soils and groundwater have been impacted by sewer lines and or historic septic system discharges. Avalon Bay's LSRP identified sewer discharges as a recognized environmental condition. This is noted on page 27 of Ecosciences Phase 1 report. Photos of underground storage tanks are photos number 19 and 20. A few weeks later, November 9th, 2011, Avalon Bay redirects Ecosciences Limited Phase 2 as redirected by Avalon Bay Communities. The scope of work proposed is limited to investigation of operating underground storage tanks and 2 abandoned underground storage tanks. That's on page 2 of Limited Phase page 2. This was a business decision which had nothing to do with the safety of citizens. Later, June 6, 2012, Maser Consulting Environmental Impact Statement is issued and reports no underground storage tanks of contamination were found on the property. This is completely against what was stated in the Ecosciences Phase 1 report, showing photographs 19 and 20 of underground storage tanks. The Maser EIS was the only document presented to the Planning Board until PCS and lawyer insisted that Ecoscience Phase 1 and Phase 2 reports be made available. Later, March 2014, Ira Whitman on page 6 in his independent report, March 2014, for Municipality of Princeton, refers to the Ecoscience Phase 1 report. This assessment has revealed the following evidence of recognized environmental conditions in connection with the site: sewer discharges, underground storage tanks, facility decommissioning requirements, inaccessible areas, also non-scope considerations such as asbestos-containing building materials, lead-based paints, and radon. Dr. Whitman goes on to say, it is assumed that it is accurate and that Ecosciences recommendations will be followed by Avalon Bay. But is this what's really going to happen? June 23, 2014, the Princeton Department of Engineering notes in its notice regarding work at the hospital site that evidence of a discharge was found near 2 underground storage tanks at the site and that 5 to 6 trucks of soil needed to be removed. This confirms PCSN expert James Peterson's statement to the Planning Board that they're contaminated by definition, and the use of the word implies a discharge. See Planning Board transcript, December 10th, 2012. Now, At a recent council meeting, when everyone voted unanimously to hire Neil Yoskin as environmental attorney, the consensus was, and if you don't mind, Ms. Casiso, I will quote you, I agree with Mr. Driscoll that we need to do everything that we can to ensure the safety of citizens. Hold on to that thought. And I ask you, have you done everything that you can to ensure the safety of citizens? Now, as a parent, I can tell you, it's no fun. I've had the experience myself to look after a child that has a serious illness. What kind of legacy are we passing on to our children and our grandchildren? It's a battle worth fighting. Now, maybe the laws are tough, but I can't believe that Judge Jacobson, she seems like a reasonable woman, wouldn't want to work with us and find a solution that is satisfactory. At the very least, delay your plan for this evening. You've got children at Community Park School System. You've got children that are going to be living at the future site. What about the workers that are on site that are at risk? You're moving the soil around. You're stirring up the toxins. I've been to all the meetings. I've been to the school board meeting, the Board of Health, the environmental meetings, and I've spoken about this issue because I know how important it is. So I have some very important questions. If somebody gets hurt on site, if there's a lawsuit, is the town liable? And if this was covered before, because I did come in late, I apologize. Who will be liable in a lawsuit in the who will be liable in a future lawsuit if someone living on the site or coming into contact with the site gets hurt or develops a long-term illness? Again, is the town liable? Because the decisions that we make now could affect our financial well-being for many years to come. So if it's a choice between using taxpayer dollars now and spending the money to get it done right to ensure people's health and safety, then I urge you to do that, to take the time now to get it done right and spend the money if that's necessary. I thought I was at the hearing, so I heard it. I don't have a transcript. I'm going to see if I can try and get it. I would urge you to get a copy of the transcript. I think it's very important for us. I think it's very important for Avalon Bay to get it right, because the money we spend now and the time that we spend now, and I know it's been a long time, and you've told me it's been a long time, but that doesn't mean you can make the residents forget what they saw and what the intention was from Avalon Bay. These are all documented things that happened. First they'd say they're going to do one thing, and then they cut back and say, well, we're going to give you half. And I don't think we should settle for that. Not where the safety is concerned. The other issues, okay, that's something else. Thank you.
Thank you, Mr. Driscoll.
Aretta Plinsky, Harris Road. Following up on what Paul said, I have one point to make on behalf of other people that live on Henry and Harris Road about promising one thing and doing another. I understand in the middle of last week, on one day alone, at least 11 trucks came out of the Franklin Avenue gate. The so-called traffic route was supposed to go out into Witherspoon. Instead, the trucks went out Franklin, made a left, again made a left on Harris, again made a left on Henry, and then went out on Witherspoon. Is this promising one thing and doing something else? Is this, what is it? You know, what residents in this quiet neighborhood are supposed to hear the trucks grinding their gears at all these turns? Now, in terms of what was presented today, 12 inches will be removed from the unpaved areas. There's a series of unpaved areas today, but what about the unpaved areas back in 1948 when the first incinerator was built? What about the unpaved areas in the mid-1960s when the second incinerator was built? if you consider settling for this 12 inches, it should be 12 inches from all unpaved areas since the first incinerator was built in 1948. There are aerial photographs, there are floor plans, there's plenty of information, just people have not wanted to look at it. And now there's acknowledgement that contaminants could have traveled down the drain line from the second incinerator room. What about the drain line from the first incinerator room? We know where that incinerator room was located. At the very least, the soil around that first incinerator room drain line, even if the drain line isn't there anymore, should be tested, not visually, not olfactory, with proper soil testing, which we all know is affordable. This proposal, as Victoria Airgood pointed out, does not address the contaminants flushed down the drain lines for 90-plus years. The same way that you have finally understood the risk of the second incinerator room drain line should be applied to all drain lines in the site. There was a statement about, by Mr. Yaskin about this is the best way to remove soil to make sure that it's not in contact with humans. I urge you to remember that this is a densely populated neighborhood. So the soil, it's the residents here that have been living with potentially contaminated soil in their gardens for decades. It's time to act on this now.
My name is Evan Yaski, Hawthorne Avenue. I think it's worth just to start acknowledging it was about a year ago that Avalon Bay received planning approval, fairly carte blanche planning approval, and through the actions of many concerned citizens, we're here today, a year later, talking about some important issues that might not have come up otherwise. And so through those actions of various citizens, many of which are in the room tonight, we're pushing forward an agenda to try to ensure and protect the safety of citizens of Princeton. A question for council. Are you able, or do you have an estimate that you could reveal to the audience tonight as to the legal fees incurred by the citizens of Princeton for this current legal action brought forth by Avalon Bay? I don't think so, but suffice to say it's significant.
I don't have them at my fingertips, but we do have them. They can
Rough
be.
order of magnitude? Rough order of magnitude?
I'd have to look. But go ahead.
Best guess? 10,000, 15, 20, 30? 50? Just a rough number.
I think we were not prepared to answer that.
I'm not saying you came prepared for it, but I'm sure you have a rough idea.
Through June, it looks like it was $20,000.
Okay. Well, June didn't. Since June, a lot has happened, and court appearances and mediation sessions, and two attorneys here tonight, so probably well above $30,000. My point being that some rather simple environmental testing could have occurred, could have been paid for by the council, by the town of Princeton, to get a preliminary sense of what is and what is not on site. Avalon Bay could have incurred those costs. I'm sure whatever the town has spent, Avalon Bay has spent a lot more. Usually the developer has a lot deeper pockets than a municipality, has a lot more vested interest in the financial outcome and is willing to pay a lot more for their attorneys to represent their interests. So they could have easily gone forth and done some preliminary testing to inform the citizens, testing that was in fact suggested by their own environmental consultant years ago, but chose not to, chose to go through the legal system, which is somewhat unfortunate. I'd like to state my that I was quite taken aback by Ms. Cecil's comments here tonight. We've seen over the years Avalon Bay representatives, some of which are here in the room tonight, frankly try to bully the council, the planning board, the people of Princeton into doing what we want them to do. Ms. Cecil tonight did a pretty good job of arguing in Avalon Bay's interest to rush to an immediate vote tonight, saying that we'll never get a better chance than we have now. One wonders, why would Avalon Bay even sign such an agreement if they stand a much better chance in just a couple of weeks with Judge Jacobson? For Mr. Yalskin, I have some questions. My understanding is that you're quite well respected and prominent environmental attorney with a practice in Princeton. I'm not sure if you also are a resident of Princeton, but I'd be interested to hear after your statements tonight, sort of summarizing the mediation session, what are your concerns coming from your professional standpoint? What, if you put yourself in the shoes of a Princeton resident, what concerns you with this agreement? What do you think might be left out? What do you think we should be thinking about that might not be in this agreement? Whether or not we have a chance of getting it through the legal process or not? What concerns do you have as to what might be a health concern, a safety concern to the people of Princeton that may not be addressed by what's been put forth in this revised developers agreement? I'm not sure if you're prepared or willing to respond to that now.
Go ahead.
There are, I live in Lawrenceville. You can't view these, you asked me to put aside the law and just view my concerns. You can't put aside the law. If, as I said, one of the anomalies of the law in this particular circumstance is the kind of testing that ideally might be required isn't required, so you get the best you can. As an environmental professional, as a homeowner, there are lots of things that worry me. I live in a house where the soil was imported onto the property. I've never had it tested, but if it came from an orchard or a farm field, it might have arsenic in it, it might have dieldrin in it. There are contaminants that are so pervasive throughout our environment that I think I can candidly say that I don't view the hospital site as a particularly troubling location. Several years ago, I represented the Borough of Princeton in negotiating a remediation agreement for a former coal gas site, manufactured gas product site, where the Princeton Library is located now. That facility operated for about 55 years in the late 19th and early 20th century. That was one of the dirtiest manufacturing processes that humans have ever devised. And it operated right here in the middle of Princeton. I can guarantee you that there are surficial impacts all over Princeton, and there is still free product under the Princeton Library. So there are a lot worse things to worry about, and I worry about them as a resident, I worry about them as a parent. I can only do what I can do. And that's a personal view, not a professional view.
Well, thank you. I appreciate your frankness on that. And my final comment, I apologize, I know I've gone beyond the 3 minutes. I'd be interested, and I think several people in the room tonight would be interested to hear from Avalon Bay if they are given an opportunity to speak tonight. It's been suggested that this is a longer-term relationship. Certainly, it's already been a very long-term relationship, one in which I personally would like to see ended tonight. But that being said, if this development does go forward, I think that Avalon Bay realizes they have a vested interest in how these proceedings end and the impression that is left in this town. I think that there are many people in the room tonight who have been involved in this process for a long time. There are journalists here who will continue to write about this issue and this development, and that they should be given a chance to speak, so that that there are people in this room who will want to tell the story, who will want your future customers in roughly 2 years to know what happened, what kind of company is Avalon Bay, what kind of company are they potentially putting their money towards and their life towards in residing in an Avalon Bay development. And I think that story will be told one way or another, and Avalon Bay should have a chance to say, this is what we did when we had a chance to do the right thing, and this is why we want to go forward in such a manner. Thank you very much.
Good evening. Linda Auerbach, Lido Street. I have two questions, one for perhaps Jack West and Mr. Kaiser, Bob Kaiser. How many people will be supervising and visually, observing on a constant basis the removal of the soil? What guarantee is in place that that actually will be done and to the depth required? Question. Second question, is the council or any of the people at the table, are any of you privy to what the agreement between Princeton Hospital and Avalon Bay was, and whether there was any information? It took Jan Weinberg to disclose the existence of the medical waste incinerator. What else don't we know about? I hope there isn't anything else that we don't know about, but is it because of the fact that it's a non-industrial site that certain things may not have been necessary to review in the sale by the hospital to Avalon Bay? So we're sort of working backwards here from the discovery by Mr. Weinberg. So the town will have to absorb the legal costs and the testing costs, etc., if Avalon Bay doesn't. Was Avalon Bay lied to by the hospital? The hospital certainly should have known about a medical waste incinerator, and if it didn't, it's incompetent, and if it did, it's fraud if it didn't disclose it to Avalon Bay. Avalon Bay, I would assume, would have a right to sue. On the other hand, was it disclosed to Avalon Bay? Are any of you privy to any of this information, and why not? I don't see why such a sale would not be a matter of public record, given the location of the demolition of the building, etc. It's hardly an industrial site as far as the dense population and the closeness. Some of us 150 feet from this site.
The sale was a private matter, and whether or not there were any agreements between the seller and the buyer remains between the seller and the buyer, and we are not privy to any such agreements.
But the town is paying the legal fees and other things, so it becomes a matter of public interest, and you pay a price to be represented by counsel, by an environmental lawyer, by Mr. Whitman, etc. Those costs were incurred because the details were not revealed publicly as part of this sale. So why is the town picking up the bill on any of this? Had Jan Weinberg not found out about this, maybe we should blame it all on you, Jan. It's all your fault. Why is the town paying for something that should have been absorbed by the hospital in Avalon Bay? And why wasn't that medical waste incinerator disclosed? And who's liable? I mean, maybe Avalon Bay is within its rights to sue if it wasn't informed about it. And if it didn't know about it as a purchaser, if it's, what was it, Eco Sciences? I've lost track in this great melodrama. Did Eco Silences, maybe, did they do due diligence before the purchase was made? I mean, anyway, the whole thing, I'm hoping that there's nothing to be concerned about. That's my greatest hope. But I am one of the old-fashioned kind of people. It isn't inherent in me not to trust people, but the way this whole thing has been carried out, it would be awfully hard to gain my trust without a certain demonstration, revelation of what the terms of sale were and what was known and by whom. And I'm sure Ms. Cecil could look into that for us. And whether it was carried out the way it was because it's a non-industrial site. Had it been an industrial site, would there have been a different proceeding as far as sale to purchaser, et cetera? You know, whatever you call it, detrimental reliance or something. I think they call it in landlord-tenant or in marital law, family law. Anyway, that's all I have to say. Thank you all for your work, and I hope that you're protected on the site.
Dozier, Hammond, Lee Avenue. Just a couple quick comments. I'm glad that the council did finally enter into these negotiations with Avalon. From what I've heard, we don't seem to have a whole lot of choices. It does sound like, from what I understood today, something's got to be done by September 6th, probably, unless we can get legal opinion that we might win in an appeal, and I'm not sure that would be a way to go. I do think that the fact that it was only posted on Friday and we're discussing it on Monday might lead us to, even if it's an overcrowded schedule on August 25th, maybe to do just a little bit more looking at it beforehand. This is, I live in the neighborhood 2 blocks away, and it is going to impact people in a radius around there, including the new residents moving in. There may not be anything else we can do, and maybe this is the best deal we can get, but I think it's worth looking at a bit more. A specific point about lead poisoning, or lead contamination, excuse me. Yes, lead is prevalent in the environment. It's out there everywhere. We know that. The question is, I think, the levels of lead. As we know, no level of lead is really good at all. But if it's a low level of lead in the soil, that's one thing. If it's a high level of lead in the soil, that could be a whole different matter. So the fact that we can in some ways test for lead and can't in other ways, I didn't get the full implications there. Lead is a very important thing, especially for child development, as we know, and to keep that down to a minimum in that area is very important to me and to the residents of the area. So those are my comments. Thank you.
Diane Perna, 23 Carnahan Place. Having worked at the hospital, I know that there are also drains in the laboratory area, and knowing that there were specific machines that tested many different fluids of the body, and those drains were used as exit points for some of those machines. So I'm very concerned that you do go ahead and be able to test those particular drains in reference to other toxins as well. Thank you.
I'm Jan Weinberg, Park Place, Princeton. I would like to read yes, okay, thank you. I would like to read the judge's order about the timetable. I'm not going to try to persuade you not to vote tonight, but I'd like to make sure this is in the record. For anyone who's napping, please wake up. I'd like this to be printed in the media as well. This matter having come before the court by way of plaintiff application for preliminary injunction relief, and the court having denied the application for its good cause, shows on this 22nd day of July 14th, hereby ordered
Jan,
that...
speak into the microphone. You want people to hear you. People at home can't hear you.
Oh, okay, I apologize. The parties shall serve paper discovery requests by August 29, 2014. The parties shall answer the paper discovery request by September 30th, 2014. The court shall conduct a case management conference by telephone with counsel for the parties on October 15, 2014 at 9:30 a.m. to discuss expert reports on damages and other discovery issues. Counsel for plaintiff shall arrange the call. Point being is there is no rush. The judge allowed for discovery. If summer vacation interferes with our good mayor being here, the judge would extend the schedule by a week if you asked for it. There's a reason that the judge allowed for discovery in this particular case and did not allow for discovery before. We don't know exactly what that is. I was in the courtroom. Paul Driscoll was in the courtroom. Ms. Cecil, Mr. Yoskin, Jack West was in the courtroom. Did any of you folks hear an indication from the judge that she was upset with Avalon Bay for being spiteful, and that's why she allowed for discovery or for the case to continue? Has anyone read the transcript of the hearing on that day or a video to get a sense of the judge's temperament? I don't think it was accurately portrayed tonight by legal counsel. Thank you.
Hi, Anita Garoniak, Harris Road. One quick question. I think Aretta got it wrong when she said that there would be 12 inches removed from the unpaved spaces. It's 4 inches. Can you tell us how that was arrived at and who made that decision?
Do you mind repeating your question? I'm not sure I really understood it.
There will be 4 inches removed from the unpaved spaces, the 4 inches of dirt.
Mm-hmm.
Can you tell us who decided on 4 inches as opposed to 12?
It was an agreed upon number. It's based in part on the township. I'm sorry, I don't know what to call the town. The municipality's specification for soil removal and backfill when it does road and sidewalk work. It was also run by Dr. Whitman to ensure that it was an adequate depth under the circumstances.
Thank you.
Further comments or questions from public? Dr. Hammoud, can you hold back for just a minute, please, and let me see if there's anyone who hasn't spoken who would like an opportunity to speak. Fine. Please.
This will be very brief. I did want to follow up on Mr. Weinberg's comments. I do believe it's very important that you remember what he said. In those comments, it made very clear that Ms. Cecil was wrong tonight, as I found her to be wrong 3 other instances in our hearings, that we must hurry tonight. This is it, and the 6th of September is it. And it turns out not to be true. Ms. Cecil, please, we're paying you good money. We want better representation, and please, council members, do listen carefully. You're paying this person to give you misinformation. I'm really worried about this, and again, I hope you will remember 2 of our major council members are not here tonight. It's incumbent upon us as a democracy to have our mayor and Ms. Howard both here with you for your sake as well as ours. And again, we want to thank you, but we want you to remember your first obligation is to the citizens of Princeton, not to Avalon Bay. We want to be fair to them, but Ms. Cecil, please, I hope you and your colleague will do a better job of representing us than you have up to now and giving us an honest informational position, not something that seems not to be quite correct from the exact evidence that Mr. Weinberg read to you tonight from the court documents. Thank you, and God bless you.
Thank you. Can I ask the clerk when the agenda packet was posted? I'll post it on Friday. Mhm.
Which is the norm, thus allowing council time to read it and the public reads it on Friday.
Okay, so the full agenda packet was posted on Friday morning.
I can double check that, whether to go back and
I wanted you to clarify that because when I looked at my own email, it was posted on the 14th. So, okay, thank you. And Ms. Cecil, I know that Mr. Weinberg read an accurate representation of what he had in front of him. Could you refresh our memory on the instructions from the judge relative to the mediation?
There's a separate mediation order that the judge entered. She required the parties to engage in mediation and to do so within, I believe it was initially 45 days of her order. I recall at the first mediation session, the mediator telling us that he had spoken to the judge and she wanted this done quickly. And the other development since the order was entered that Mr. Weinberg read into the record, and as you said, he read it accurately, but in the interim, Avalon Bay, as I indicated previously, filed its motion for summary judgment and made that returnable on September 6th. So it has, through perfectly proper legal channels, accelerated the time frame considerably because it's asking the judge now to make a decision on the merits on September 6th.
Thank you. Again, are there any further questions or comments from the public? If not, I'll bring questions and close that part of the hearing and bring questions and comments back to council.
Well, I think we had some questions that weren't answered from the, there was a question about the chimney. Did we answer?
No, that question was not answered.
Right.
About the incinerator, about the staff.
The chimney, and when that's demolished, how can we be protected from the heavy metals that may be in the chimney stack?
Neil, you might want to speak to this. The question about the incinerator.
I don't think I can answer the question. There's a distinction in the developer's agreement between the environmental conditions and then you have a very robust demolition plan. I'm not familiar with the demolition plan. It's not within my purview. I guess the concern is that when the chimney's demolished, that there's a burst of dust that even with air monitors would escape. That's a construction issue. I don't know how that's addressed.
Perhaps I could comment. There'll be 5 monitors on site, so we'll be certainly checking for dust. Also, in the demolition plan, there's a requirement that materials be wet down. So as those parts of the chimney fall to the ground, they'll be wet down to avoid dust from flying to other locations and so forth. And then, of course, all that material will be trucked off-site.
And then there was a question about the septic system, which I also had that question. If evidence of a septic system is found, what happens? If not, how can...
There's 2 parts to that. One is we actually don't know that there is any evidence that there was a septic system. We do know that in 1909, the main part of the hospital building was hooked up to public sewer. Don't know if there was a septic system on another part, but in the developer's agreement, there's a provision that if any evidence of a septic system is found, that material will be tested.
I wonder, President Miller, if you would like to speak to the issue of the mayor's absence and Councilwoman Howard's absence. That came up a couple of times.
Yeah, I would like to comment on that. Both Councilwoman Howard and Mayor Lempert participated in the closed session that preceded this meeting. And both Councilwoman Howard and Mayor Lempert expressed support for the mediation that had taken place and full support for the resulting document that came out of the mediation. They cannot vote tonight. They're not here. But they ask that I convey their support for the work that was done leading to the document that's before us.
I think there were another group of comments having to do with who will be liable if there's a future lawsuit. I think, Ms. Cecil, you might answer that. What is the town's liability? Will we, if we do testing, not do testing? And there was also an insinuation that Judge Jacobson might be willing to work with us, I think, which is a different, well, I know from speaking to you that you feel that her sending this to mediation was working with us, that actually was a gift on her part, that had she been asked to rule that we would have gotten no remediation. But can you talk about the liability going forward?
I'm not aware really of any way that the town could be held liable, especially as the whole issue here is that the town, I mean, at least as Judge Jacobson, as Avalon Bay has argued, and as Judge Jacobson indicated she found compelling, that the town has no authority to require any testing to begin with. So to then argue that the town would be liable for not requiring something that it has no authority to require, that's a stretch. Moreover, there are all kinds of immunities that are built into the law that apply to governments, and then Mr. Yaskin can also address from an environmental perspective any liability issues, but there are none that I'm aware of. As far as I know, under the law, if any contamination is found on this site in the future, it will be Avalon Bay's responsibility. It will not be the town's.
And about our ability to go test on someone else's property?
Oh, we have none.
We cannot do that.
We can't go onto someone else's property and just test, no.
I have nothing to add to Ms. Cecil's comments.
I remembered another question that someone asked that I think has bearing on what the urgency is, and that is why is Avalon Bay agreeing to do this remediation, which is beyond required by law? If they feel that they would win, if we, didn't do this agreement and we went forward, and they would win, why don't they just do that? And why are we getting remediation out of Avalon Bay?
Lawyers will always tell you that there is always risk in litigation. Always. Cases that you think you should win and couldn't possibly lose, you lose, and vice versa. So I'm assuming that Avalon Bay perceives a certain risk. But beyond that, I'm just going to reiterate what Ms. Cecil said. Avalon Bay's contractors are wrapping up on site right now. If they don't have the opportunity to begin the demolition work and continue working, they're going to demobilize, and the cost of demobilizing and remobilizing, I think is, I would imagine that that's motivation to Avalon Bay to do make a business judgment that it's better to settle. Somebody said before that we were trying to reach a result that is mutually satisfactory. Compromises, the definition of a compromise is something that is satisfactory to neither party. You get what you can. But I think that, I'm assuming that Avalon Bay theoretically perceives some risk, but has a distinct financial interest in moving forward now.
Mr. Kaiser and maybe Mr. West, could you talk about who's on site from our staff, from the state officials on any given day? What kind of monitoring is going on?
We'll have a number of people on site depending on the work that's proceeding, and we coordinate who's going to be covering on a staff-wide basis, and members of those staff would be individuals from the engineering department, including Mr. West and myself, the building department who monitors the work, the health department, and we would have the ability to call in Dr. Whitman as necessary. and when sewer utilities are involved, we would call in members of the sewer operating committee. So we have an array of people that we will use and that we will coordinate with to have the proper individuals there to monitor the work that's proceeding at that time.
There was one other question about when the testing would take place, whether it was before the demolition.
Right, before, during, or after demolition. Remember, the two areas that there was going to be soil testing that's no longer going to be done because the soil is going to be removed, that was scheduled prior to demolition. But that testing is no longer taking place. The testing under the floor drain in the incinerator room, I assume that's pre-demolition. They're just going to go in, break up the floor, and pull up that drain?
We certainly need to do the televising that drain while you have access to it prior to demolition.
And then what about the other drains that were mentioned? Are they going to be addressed or looked at?
Well, there's two. Maybe I should let you answer this question, Bob, about when drain lines get daylighted, what happens?
Well, the drain line that will be checked from the incinerator area, there's a drain at the bottom that can provide access, and a camera can be placed down that line and would continue all the way to the where it connects to the sanitary sewer service to the street. So we would envision that work proceeding early on and determining whether there's any breaks in the line or any openings where we would want Avalon Bay's people to dig down, expose that area, and test.
But we don't care about the other drains?
Well, I was going to say, my understanding is that there are two connections to the public sewer system, at least one of which is going to be used, which is intact.
Right. The one that goes out to Henry will be utilized, and then the one that goes out to Witherspoon will be no longer in use.
Now, the one that goes out to Witherspoon, the laboratory drains that somebody talked about, they drain through the building, and they would make their way to one of these two laterals. The one that's not going to be used when it's daylighted, the plan, the environmental protocol, calls for it to be inspected. If there are any breaks in it, then there will be sampling along the breaks.
Okay, thanks.
The last question that I was able to capture was the question about the traffic coming out of the Franklin lot and whether it's following the protocol, going the right way. Is it the hospital that's using that lot, or is the university still using that lot as well for their...
I don't believe the hospital is utilizing that lot, but...
So is that the university?
I'm not sure. I mean, I guess the only thing is, we had one case where a truck did come in from some of the back roads. We talked to the contractor to reiterate that they can't do that, and everything was fine. All I can say is if the public does see trucks that are utilizing Henry or any of the back roads, just let us know, and we will put a stop to it immediately.
Are we under agreement to let anybody use that Franklin lot at the moment? Or do we have possession of that?
No, we do not have possession of it. It is owned by the university.
Still.
We have access to a portion of it, and they're using the balance of it from time to time to stage for their project on Baird Lane.
Just to clarify, I don't think that's what was said. I think what was said was that the construction vehicles exited by Franklin Avenue.
It wasn't a Franklin lot.
Oh, it wasn't.
Yeah, it wasn't. No, and I will say that there were a few trucks that they got really lost, because I spoke to a driver myself.
Okay.
Well, they actually twice went down Carnahan and around Conti's and over Witherspoon, and then made a right, which was even worse. So I think they were, I think they were enjoying the neighborhood, but I do think they were lost.
We're meeting with the contractor tomorrow. We'll make sure that doesn't happen. I mean, obviously we can't stop some of these drivers, but we reiterate to the contractor, and they've been pretty good about it.
Tell us what so that we know. Egress from, for instance, this material.
The route is directly out to Witherspoon Street, turn right on Witherspoon, down here to Cherry Hill, and access 206 at that location.
They can use the front.
Right, also they can go south on Witherspoon to access Route 1 as well.
Well, they can't go to Nassau Street. They are allowed to go Witherspoon to Paul Robeson. However, the contractor has indicated because of the tree canopy on Paul Robeson, their bigger trucks can't use that route, but they should not be going to Nassau Street. They should either go Paul Robeson to 206. That's the route.
And you're meeting with them shortly and...
Tomorrow.
Tomorrow, and you'll take up that issue.
At this point, any further comments or questions from council? I think I made it clear that I have closed the public comment part of the meeting. And I'm very sorry if you didn't get a chance to speak, but there was ample opportunity provided for public comment, and I don't see anything to be gained by reopening that part of the meeting.
I didn't understand something they said just now. It was in post-public.
Please go ahead.
If the chimney...
You need to speak into the microphone, though.
At the mic, please.
Tesh Patel, Henry Avenue. If what I thought I heard was that when the chimney's going to be demolished, it'll be wet or things like this, and it'll be tested for whatever the contaminants. And then I guess what they meant is presumably there won't be contaminants, or will be, that's my confusion, will or won't, and then they'll truck it away, right? So is the same method of removing the debris from the chimney, etc., is it the same whether there are contaminants or there are not contaminants? Is there a difference there?
Avalon Bay has to obtain clearance from wherever they dispose of material. So whoever's receiving that material requires basic type testing.
Yeah.
They would provide that information to determine where those materials should be disposed.
Okay, so
actually, if I can interrupt, I think, Mr. Kaiser, part of the point of the question might have been, suppose an air monitor goes off while the chimney or anything else is coming down. What happens? That might be helpful to explain.
If the air monitor goes off, we are immediately notified, all work stops, and the situation is corrected that caused the monitor to go off.
Yeah, so following that logic, right, roughly speaking, I think you said in part of those comments was, hey, there was some soil, two spots were going to be tested. And I think someone made the point that, oh yes, well, we're not testing them anymore because we're removing them. Do you recall that? Yeah?
They're not being removed from the site. They're being excavated, segregated on site, and will be used in excavation and foundations subsurface.
Okay. So, all right. So that's what's going to happen to them. But if the testing had taken place and there were contaminants there, probably that's not the place to put them, right? So because someone decided to dig the place up before, and in other words, prevent the testing and suggest, let's dig this thing up and bury it over there or wherever, we're not going to test. But thinking along the lines as you did before.
Actually, if I could stop you, Mr. Yaskin, could you please answer the question, if testing had proceeded, can you describe what would have happened?
If testing had proceeded, the state of New Jersey has 3 categories of soil classification that with 2 cutoffs. You have what's called an unrestricted residential use classification, which soil can be contaminated, but it's contaminated at a level that scientists have determined can safely be used without any controls whatsoever. That's the unrestricted standard. If you go over that standard, you're between the unrestricted standard and the restricted standard, which is sometimes called the industrial standard. Those soils you can reuse on site, provided that you encapsulate them. If you are at a high level of contamination, then material gets trucked off site, it gets tested. If it meets, it's either deemed to be non-hazardous solid waste, it can go to a landfill and be used as cover, or if it's deemed to be hazardous waste, then it goes to a hazardous waste landfill. But then you're talking about heavy contaminants.
Okay, so if I can just follow up along this line, two questions with respect to that. Would you expect at the hospital site to find the worst level that you just described? And also, for the medium level, are there any examples either in town or in the state that people might be familiar with of reuse of soil along the lines of what you just described?
I'm not an environmental professional. I'm not a scientist, so I would, my informed lay opinion is you would not see those high concentrations of contaminants at this site. The best example of a site that meets the medium layer is the Princeton Library. The Princeton Library has what's called an institutional and an engineering control. The engineering control is a cap. Below the building is a impermeable layer. And then the institutional control is a deed notice to all future persons in the chain of title that this is a contaminated property and you can't break that cap for more than 45 days without dealing with New Jersey DEP. So the Princeton Library is the best example of that.
So just to point out, I think it was the same gentleman that said all things, being a human being rather than a lawyer or something, that as a concern, his was the thing underneath the Princeton Library, which he just mentioned again. Again, your question, Mr. Simon, I'm not sure I follow. He's not the expert. He doesn't know what he doesn't have a comment. But you were saying, what were you trying to get at? Like, it's not going to be that dangerous? Is that was that your guess?
I was trying to get clarification on both the levels and
yes, but he's not the guy. He said, I can't speak to the levels.
And he answered that.
Right. So what was your point, though? How dangerous the soil was? Because if that was your point, it would be tested.
Yeah. I think we've gone far enough with this line of questioning. I don't think that we're here to cross-examine.
That's fine. But my point was, the soil won't be tested. It doesn't make any sense. You should test it. Whether you're going to bury it or not, that's not the end of the world. It wouldn't hurt to test it, would it? But again, I appreciate the time.
Thank you.
I just want to say.
Go ahead.
Okay. Thank you. Let me publicly thank Councilwoman Joe Butler and Councilman Bernie Miller for participating in the mediation sessions. Representing a town like Princeton is not easy, as you guys can see, because in every difficult situation, you may have so many well-intended residents that in their minds, they're trying to protect and preserve the character and health of all of our citizens. But sometimes you must understand that both sides have rights. The council members have to listen and filter out from the discussions what is the best for the majority of Princeton residents. We must understand that as elected officials, we're here to do what is just and what is lawful according to our current ordinances and laws that we have in place. There was an extreme outcry from members of the community as well as all council members to have more environmental testing done on the hospital site. And the council assured members of the community that we will ask for more testing to protect our citizens. The council was aware that because the hospital site falls under the state DEP regulations, that we did not have the legal authority to make Avalon Bay do all the additional testing we wanted. But we also knew that our children, my children along with the schools and neighborhoods, were close to the demolition site and may be at risk. So the council, in the unanimous decision, vote to have Avalon Bay do more environmental testing. As you heard, the judge mandated that the court mediation between Princeton and Avalon Bay. As was mentioned, this brings us here today, as you have heard. Agreed to do more testing. Well, as you have heard, Avalon Bay has agreed to do more testing than they are required to do by law. As you have heard, Avalon Bay will do more air monitoring than they are required to do. And as I understand, that it is certain, if we do not accept the court mediation agreement, we went back and forth with timelines, we will end up back in court, and the judge or Avalon will, I am 90% sure, will throw out the additional testing that Avalon Bay has agreed to do. The judge will simply refer us to what the state DEP requires for hospital site demolitions. And this would be a major loss for the residents of Princeton. Let me say that I want to thank everyone, so many of our engaging community members for their support and concerns over the site. And we may not be at this point, we wouldn't be at this point without all you guys' help. I mean, you were terrific. But I have to tell you, after listening and reading where we are today, that I have to vote yes for this developers agreement.
On an issue this important to the community, I think the members of council owe an explanation to the public of our vote and our intent. As I look over the agreement and as I hear the discussion of the agreement and hear people's concerns, and I think back to the timeline which all of us up here and many of you out there lived and worked through. My assessment of the agreement we have is that it accomplishes substantively everything that we asked Avalon Bay to do in April. It does not do it in exactly the same way, but in terms of protecting public safety, my assessment is that it accomplishes precisely the same goals. And I am satisfied with that, that it has done so. I believe it is our obligation to protect the public safety, and that is the majority, it is the minority, it is the individual. I believe that we are actually doing that. I do want to thank the members of the public who have been so diligent in their efforts to make sure that this is the safest process possible. I also do want to extend my appreciation to Councilwoman Butler and Council President Miller for their efforts in the mediation process, as well as I do want to thank our attorneys and our staff for their roles in this process. It can seem at times like a thankless task, but I think, frankly, that Princeton has achieved every goal it has set out to achieve in this agreement, and I intend to vote in favor of this amendment.
I think we have a window where it's cheaper for Avalon Bay to give us the protections we're asking for that they're not legally required to do. And I believe that the only reason Avalon Bay is working with us is for business reasons. I feel it would be irresponsible to risk losing those protections with further delay. I also have confidence in our professionals, and I think it's in all of our interest to listen to them. And I also want to thank Joe and Bernie and all the other members who worked on this agreement, because I agree that we've gotten a pretty good deal.
Thank you. I think my colleagues really have said most everything, and I think that the fact that I attended the mediation give some indication that I intend to support it. I apologize to Ms. Cecil for the abuse she had to endure tonight, but I want to assure everyone that the mediator was also clear that we needed to move expeditiously, that this was in our best interest. And so I don't think that that's advice that we could afford to not heed. Above all, I think we kept the public safety in mind, what we could do that would be in the best interest of the public safety. We've gotten some emails basically asking for us to fight this to the finish, that people saying that they're willing to have their tax money go to pursuing additional legal appeals. But if you're really interested in public safety, you have to see that we needed to make a deal. We could not risk, given the information that we had from our attorneys, that we would likely lose this on appeal. We could not run the risk of jeopardizing public safety in that matter. It's just too important to us. So I want to thank Council President Miller for his help, and I also am going to support this.
Like Ms. Butler, I also participated in the mediation, and mediation was a negotiation. It was a mediated negotiation, mediated by a state-appointed mediator, appointed by the judge. In case there is any doubt in anyone's mind, foremost in our minds, as we went through the mediation process, was the protection of the health and welfare of the present residents and the future residents of Princeton. And what we sought was a way to ensure as best we could that if there was contamination on the site, that residents of the site, visitors to the site, people passing by the site during construction would not be exposed to potential hazardous materials. The approach we took was not one of testing, because testing can never guarantee that the site is contaminant-free. The approach we took was to find a way to separate humans from contact with any potentially hazardous material, and we believe that we have done that. And for that reason, I do also support the outcome of the mediation. And with that, I'll ask for a motion.
So moved.
Second.
To approve the resolution. Madam Clerk, will you call the roll, please?
Ms. Crummiller?
Yes.
Ms. Butler?
Yes.
Mr. Liverman?
Yes.
Mr. Simon?
Yes.
And Mr. Miller?
Yes.
Motion carries.
Thank you. And there being no other business before council this evening, do I hear a motion for adjournment?
So moved. Second.
Meeting adjourned.